settlement. We understood at that time that decision was taken by you following a meeting with Tom Crone and Colin Myler, but that you were not aware or made aware at that meeting of the detail of why a settlement should be reached, and in particular the existence of the For Neville email. As you know, we subsequently heard from Tom Crone and Colin Myler that they say they did make you aware of the existence of that email. Would you like to say whether or not you still assert that you had no knowledge of the email?
Yes, and thank you very much, Mr. Chairman, and to all the committee members. The substantive meeting that occurred on the 10th of June in 2008 was for the purpose of gaining the authorization for Mr. Crone and Mr. Myler to increase the offer of settlement that they had already made on a number of occasions to Mr. Taylor and his lawyers. The meeting, which I remember quite well, was a short meeting, and I was given at that meeting sufficient information to authorize the increase of the settlement offer that had been made, or offers that had been made, and to authorize them to go and, or Mr. Crone to go and negotiate that settlement. But I was given no more than that. Certainly, evidence was described to me that indicated that the company would lose the case if it litigated, but the nature of the For Neville email, so-called For Neville email, insofar as it was described as For Neville, which it was not, any wider spread or evidence or suspicion of wider spread wrongdoing, none of these things were mentioned to me, including the detail and substance of the leading counsel's opinion that had been sought by them and received by them earlier. It was only sufficient information to authorize them to increase the settlement offers that they had already made.
Even if it wasn't described as the For Neville email, were you made aware of the existence of an email that contained the transcript of voice intercepts, which, in Tom Crone's word, was fatal to your case?
Yes, and I think this is an important point to just be very, very clear on, if I may. The email that is now known as the For Neville email was important for two reasons. On the one hand, it was important because it was a transcript of voicemail interceptions that were made on behalf of the News of the World, and that was seen as evidence and as sufficient to conclude that the company would lose the case. There was another part of that email which was important, which was that it was so-called For Neville, and that it named another journalist in that email. And that second part, that importance, was not described to me in any detail or at all. And it was not described as the For Neville email. And I want to be very clear, no documents were shown to me at that meeting or given to me at that meeting or prior.
So it is now your position that you were made aware of the existence of an email that was extremely damaging to your defense, that nobody else was involved?
Yes, and I think as I testified earlier in the summer to this committee, I was made aware that there was evidence that the transcript existed and that it was on behalf of the News of the World. It's dual importance, if you will, that it was the For Neville email, that it also was perhaps the beginning of suspicion that other individuals were involved at the News of the World, was not described to me, and the email was not shown to me either.
Right. So you did not see a copy of the email?
No, I did not.
And were you aware of the legal counsel's opinion that had since been obtained?
I was aware that leading counsel's opinion had been obtained, but it was described, the leading counsel's opinion was described to me as to do with damages, and the estimate of damages were the case to be litigated and lost. It was not shown to me, the leading counsel's opinion, nor was it described to me the other things in the leading counsel's opinion that I know has been provided to you that were not to do with damages.
And finally, we have since learned from Farrers that it is suggested there was a previous meeting which you had with Colin Myler, for which Tom Crone supplied a brief at the end of May. Do you remember that meeting?
I think you're referring to a note that Mr. Pike of Farrers wrote describing a conversation that he had had with Mr. Crone. And just to be very, very clear, when I've now seen this note as well that I hadn't seen before, in that note, Mr. Myler suggests or says to Mr. Pike that he spoke to James Murdoch. He does not say there was a meeting. He refers to a conversation that he had with me, that he allegedly had with me. Neither Mr. Myler nor I recall that meeting or that conversation or telephone call or what it might have been. As I've testified, the first substantive and only substantive meeting that I recall and conversation that I recall about the matter was the June 10th meeting with Mr. Crone and Mr. Myler, although I can't rule out whether or not he called me or got me in the hallway or something like that for a brief conversation.
I understand. My colleagues are going to return to some of these questions in more detail, but before they do, I think Jim Sheridan wants to concentrate on perhaps events a little beforehand.
Yeah, thanks, Chair. Good morning, James. James, when you took over from Les Hinton in 2007, what did he tell you about the Goodman case and the settlement?
First of all, in December 2007, I returned to News Corporation as regional chairman for all of our European and Asian operations, which included News International, along with 5 other large entities in the area, just for clarity. But in the absence of a full-time CEO after Les Hinton moved to the United States to I had more direct responsibility for a period of time of News International. At the time, Mr. Hinton did not discuss with me any of the matters around Mr. Goodman and the entire employment of Mr. Goodman, his subsequent arrest and conviction, and the settlement matters that this committee is aware of, that we've provided documents around, all predated my presence in the company, and I had no discussion with him about it. He didn't raise it with me or brief me on it.
Did you ask?
Pardon me, did I?
Did you ask?
Did I ask him about the Goodman settlement in particular?
Yeah.
No, I did not.
So this significant settlement has been paid out, and you have not asked anyone in the company the background to it? It was
some time before I had joined the matters affecting Mr. Goodman and Mr. Boncaire. Those convictions, the arrests were well over a year before, a year and a half before. Something like that, and there was no reason at the time to believe that it was anything other than a settled matter that was in the past.
But given the fact there's a significant amount of money that could have serious consequences for the company for future discrepancies, you don't think it's proper that you should ask that we make sure this doesn't happen again?
Well, at the time, certainly at the time I would say I received, and the company relied on assertions that police had closed their case, that internal investigations had occurred, that 2 people had been successfully prosecuted and went to jail, and so on and so forth. And I think it was seen as a matter that was in the past, that accountability had been delivered, that the police had successfully prosecuted their case and closed the case in the investigation. So there was no prompt or reason to revisit a particular settlement matter that was well within Mr. Hinton's authority as chief executive earlier to make a judgment on.
But Les Hinton also told us that your father was very concerned about the Goodman case. Why was he concerned?
Very concerned about the Goodman settlement or the Goodman case? I think this is, again, before my time in the business, but I think certainly when a journalist was arrested at one of the newspapers in the group, it should have been a matter of concern for the chief executive.
Yeah, but so you never said to your father, why are you concerned about the Goodman case?
I was not at News International or News Corporation at the time. I was.
You're a family, I can imagine. Really, you do speak to your father now and again, I suppose.
Yes, I don't think we discussed the News of the World matter prior to
the Goodman case.
The Goodman case, nor the News of the World matter.
So you wouldn't think to say to your father, like any normal son would do, Father, why are you concerned?
Well, he didn't raise it with me, and it wasn't anything to do with my work at the time, and it simply didn't come up between us.
The last time you were here, along with your father expressed that his view that he was extremely humbled by the whole event. Do you feel the same way about your position?
I think I've had some time to reflect on all of these events, and it certainly it's appropriate to reflect and to I think the whole company is humbled by this, and what we're trying to do and what I'm trying to do is learn from the events over the last number of years, try to understand why the company couldn't come to grips with some of the issues in front of it in as fast a way as I would have liked or the company would have liked, and learn from those. So yes, I think we're all humbled by it and trying to improve the business, improve the structures and leadership across all of the operating companies to make sure that these things don't happen again, because they are something that I'm very sorry about.
Well, just on the question of not happening again, and just finally, have you or News Corporation sought or received any technical advice that would stop phone hacking in the future?
How do you mean technical
have you
advice?
spoken to, for instance, telephone companies to say, how can we stop this as a company? Is there any technical advice that we can get to make sure this doesn't happen again?
Well, I think it's the telephone companies, and I don't know the technical details of what a telephone company might do. Yeah. We have not sought to advise telephone companies on the matter of voicemail interceptions. No.
Thanks, Jeff.
Thank you, Adrian Saunders.
Good morning.
Good morning, Mr.
Last time I asked you if you were familiar with the phrase willful blindness, and you stalled so long that your father had to interrupt and answer for you. Have you had time to consider the phrase and tell the committee what you think it means?
Well, I think you described to me at the time, Mr. Sanders, what it meant, and I think that what I've reflected on is really where in this process were there places where the company could have heard the alarm bells, if you will, or seen these alarm bells more clearly, and to reflect on them dispassionately. And I think if there was a mistake, I think, or a shift that we need to focus on, it was the tendency for a period of time to react to criticism or allegations as hostile or motivated commercially or politically and whatnot. And what we didn't do, I think, necessarily is reflect as dispassionately as we might have amongst all the din and clamor around a large business like this around the world, to be able to try to pick out those things that we could react to differently. But at no point do I think the company suffered from willful blindness on my part or others.
I mean, throughout the inquiry you've claimed that you didn't know the detail of what was going on in your company. So do you think that internal evidence about phone hacking, for example, was kept from you?
It's clear to me that in 2008, for example, the information that I received around the Taylor case was incomplete. And it's also clear to me that in 2009, upon allegations arising in a newspaper about the Taylor case, that the full extent of the knowledge within the business or the evidence within the business, as well as with the Metropolitan Police, was not made clear to me. And that's something that I'm very sorry for.
Who should have told you about it?
I think it's important to remember that after the resignation of Mr. Coulson in 2007, Mr. Hinton brought Mr. Myler in as an outside person who had a responsibility and a remit to both clean up the issue, investigate the issue, and move the company forward and the newspaper forward in a way that made sure that these things couldn't happen again. And if he had known, which is an if, that there was widespread criminality or that there was evidence or sufficient suspicion of that, I should think he should have told me those things.
When The Guardian first reported in July 2009 that thousands of mobile phones had been targeted, News International responded with an aggressive denial of the allegations. Why did you allow that statement to be issued?
In 2009, it was the summer of 2009, and it was a year after the Taylor matter. And as I said to you and I testified to this committee, I think the company did push back too hard within 24 hours of those allegations emerging. And please recall that the relevant document, the so-called Fornevel email, was a document that the police had possession of. The chief of police issued a statement saying that that same matter had been a matter of careful and extensive investigation by experienced detectives, and that there was no new evidence to warrant further investigation. And as I testified to you in July, we relied on both the assertions, repeated assertions from inside the company around the quality and scope and breadth of the internal investigations that had been done in 2006 and 2007, the repeated assertions and reassurances by the police publicly that there was no new evidence in the matter, as well as the third-party